Because Judge Boasberg did know one thing. He knew that Jack Smith was a partisan Democrat engaged in an effort to go after Donald Trump, that he was subpoenaing over 400 Republicans. So the one thing he knew is all of these targets were Republicans. So the only conceivable basis for Judge Boasberg signing these orders one after the other is an animus that says every Republican on planet Earth, every American who voted for Donald Trump, there is reasonable basis to believe they are criminals.
Senator,
I'm done with your question.
I'm sorry.
There is no other basis for his signing that order. He knew that. He knew Jack Smith. Welcome to the fast food counter at McDonald's. Whatever you want, all the fries you want, I will sign.
This may look like a heated exchange about a single judge, but it's actually a test of whether the American justice system still operates on law instead of loyalty. What's really being tested here is whether secret court powers can be used against elected officials without accountability or public scrutiny. This raises broader questions about how far prosecutors and judges can go before constitutional protections become optional. In this video, we'll break down how this moment exposes a deeper struggle between political power and judicial restraint.
Let's start with Judge Boasberg. Professor Luther, is it consistent with the judge's oath of office to sign an order for which there is zero basis in law and zero basis in fact?
Absolutely not.
Is it consistent with a judge's oath to do whatever a prosecutor asks him without inquiring as to the facts or the law?
It's completely inconsistent.
Judge Boasberg signed multiple orders. I'm holding one of them in my hand. That's his signature at the bottom. Ordering the phone companies who had been subpoenaed not to disclose to the members of the Senate and the members of the House that their phone records had been subpoenaed. As you noted in your testimony, that order is directly contrary to federal statute. Congress in 2004 made it illegal for a phone company to disclose a senator's phone records without notifying the senator in question. Is there any basis for a judge to disregard unambiguous federal statutory language?
Absolutely not.
Judge Boasberg signed an order that says, quote, "The court finds reasonable grounds to believe that such disclosure," in other words, informing the senators their phone records had been subpoenaed, "will result in the destruction of or tampering with evidence, intimidation of potential witnesses, and serious jeopardy to the investigation." Is there any conceivable basis for Judge Boasberg signing that, particularly given Jack Smith's testimony now that Judge Boasberg had no idea whose phone records he was signing off on?
I've been struggling for the last few weeks to come up with one, but I can't. And I'll mention we wouldn't even know about this if it weren't for Chairman Grassley's oversight efforts.
That is true. And Professor Vladeck, you suggested the remedy for an erroneous decision is appeal. Judge Boasberg signed a secret non-disclosure order that was ex parte with only the Department of Justice in front of him. Is there any conceivable universe in which anyone could appeal that?
So, Senator, as you know, there are circumstances in which the providers can decline to comply. Indeed, I believe in one of the cases, Verizon actually said it was not going to comply with the NDO. I believe that's part of the record as well. And those orders are themselves also subject to challenge in court. Now, Senator, you and I have had this conversation for a long time about how there are lots of gaps in federal law when it comes to the targets of surveillance not being able to object.
Did the targets of surveillance know about this?
No, but I would also remind—
Could the senators whose records were subpoenaed contrary to federal law appeal it?
So, no, but of course, Judge Boasberg didn't know, first, that these were senators, second, that their
nor did
communications were covered.
Professor Vladeck, nor did he inquire. And in fact, I'm going to go back to Professor Luther's statement, because in an ordinary circumstance, a judge entering an order that he doesn't know who it's applying to, he doesn't know any facts, he doesn't know anything, on the ordinary basis, you'd say, yeah, there's zero basis in fact, but there is actually an explanation for why he did so. Because Judge Boasberg did know one thing. He knew that Jack Smith was a partisan Democrat engaged in an effort to go after Donald Trump, that he was subpoenaing over 400 Republicans. So the one thing he knew is all of these targets were Republicans. So the only conceivable basis for Judge Boasberg signing these orders one after the other is an animus that says every Republican on planet Earth, every American who voted for Donald Trump, there is reasonable basis to believe they are criminals.
Senator,
I'm done with your question.
I'm sorry.
There is no other basis for his signing that order. He knew that. He knew Jack Smith. Welcome to the fast food counter at McDonald's. Whatever you want, all the fries you want, I will sign, ordered, ordered, ordered. That is perfectly fine if you are the chairman of the DNC. Being a partisan hack, or for that matter, the chairman of the RNC, either side can be partisan hacks. Judges are expected not to be. And I would point out this is a pattern we've seen before for 4 years during the Biden DOJ. We saw the Department of Justice refuse to enforce the law when violent protesters were outside the homes of Supreme Court justices. It was directly contrary to 18 U.S.C. Section 1507. It was a felony on national television being committed over and over and over again. And Merrick Garland, a rogue partisan attorney general, refused to enforce the law. Why? Because he supported the objectives of the protesters. That kind of hypocrisy, let me be clear. I would object to an order that found Democrat members of the Senate, absent real and meaningful evidence, were likely to be criminals. That's what Judge Boasberg signed off on.
In that searing moment when Senator Ted Cruz held up Judge Boasberg's own signature and read aloud the words claiming there were reasonable grounds to silence phone companies and keep lawmakers in the dark, something far deeper than a procedural dispute came into view. The argument wasn't just about a line of legal text or a single non-disclosure order. It was about whether the machinery of American justice is still bound by law or whether it can be bent quietly and without challenge to serve power. Cruz's charge was simple and devastating. A federal judge, sworn to uphold the Constitution, had signed orders with no factual foundation, no legal authority, and no meaningful knowledge of who was being targeted. And yet those orders carried the full force of the state. What we witnessed in that exchange was not merely a senator interrogating legal scholars, it was the collision of two visions of government. On one side stood the principle that no one, not a prosecutor, not a judge, not even the most powerful office in Washington, is above the law. On the other stood a reality that feels increasingly familiar. Decisions made in secrecy, justified by vague claims of necessity and insulated from the very oversight that is supposed to protect the public. When Professor Luther said there was absolutely not any basis for a judge to disregard clear federal statute, he wasn't speaking in abstractions. He was stating a bedrock truth of constitutional order. Laws passed by Congress are not suggestions, they are commands. Yet, according to the record laid out in that hearing, Judge Boasberg signed orders that directly contradicted a statute designed to protect elected officials from secret surveillance. A law passed in 2004 made it illegal for phone companies to hand over a senator's records without notifying that senator. The idea was simple. Transparency is a shield against abuse. But those orders told companies to stay silent, claiming that disclosure would somehow endanger an investigation. As Cruz pressed, the judge didn't even know whose records were involved. He didn't know they belonged to members of Congress. He didn't know the facts. And still, he signed. That is the moment that should give every American pause. Because a justice system that operates on blind trust in a single prosecutor's request without inquiry or verification ceases to be a system of law. It becomes a system of permission. And when permission is granted behind closed doors, with no path for appeal and no way for the targets to even know what has happened, the safeguards of democracy start to erode. Professor Vladich pointed out that there are limited mechanisms for providers to push back, but even he had to concede that the senators themselves had no way to challenge an order they never knew existed. Cruz's most controversial claim, that the only thing the judge knew was that the targets were Republicans, cut to the heart of the political tension surrounding this case. He argued that when Jack Smith was pursuing more than 400 people connected to Donald Trump, the judge's willingness to sign sweeping secrecy orders suggested something more than neutrality. Whether one agrees with Cruz's framing or not, the underlying concern is unavoidable. When courts appear to align, even implicitly, with one political faction, the perception of fairness collapses. Justice must not only be done, it must be seen to be done. The analogy Cruz used, comparing the judge to a clerk at a fast food counter signing off on whatever is placed in front of him, was meant to shock. But it carried a deeper truth. Judges are not supposed to be rubber stamps. They are supposed to be the last line of defense between the power of the state and the rights of the citizen. When they stop asking questions, when they stop demanding evidence, when they stop reading the law with care, they become enablers of whatever agenda walks into their courtroom. This hearing also pulled back the curtain on a broader pattern that has troubled many Americans. Cruz reminded the room of times when laws were ignored because enforcing them would have conflicted with political objectives. When statutes are applied selectively, when some violations are overlooked while others are pursued with relentless energy, trust in the system breaks down. The rule of law cannot survive if it becomes a tool of convenience rather than a standard of conduct. And that is why this moment mattered so much. It was not about one judge or one set of subpoenas. It was about whether the American system still believes in limits. Limits on prosecutors, limits on judges, limits on the reach of government into the private lives of those it governs. When secrecy replaces accountability, power grows unchecked. When accountability disappears, liberty soon follows. The framers of the Constitution understood this danger. They built a system of separated powers precisely because they knew human beings, even well-intentioned ones, are tempted by authority. Congress writes the law. Courts interpret it. And when either steps beyond its role, the balance is broken. In this case, the law was clear. Notification was required, and yet it was set aside not by a vote of Congress, but by a signature on a piece of paper few people were ever meant to see. As the hearing room fell silent after Cruz's final words, that's what Judge Boasberg signed off on. The weight of that accusation lingered in the air. It was not a casual remark, it was a warning. A warning that the institutions Americans rely on for fairness and justice are only as strong as the people who defend them. When those defenders falter, when they grow comfortable with secrecy and expedience, the damage is not confined to one party or one investigation. It spreads across the entire republic. This is why oversight matters. This is why sunlight matters. And this is why moments like this hearing cannot be ignored or dismissed as just another political clash. They are reminders that the health of a democracy is measured not by how it treats the powerful when it is convenient, but by how rigorously it follows its own laws when doing so is difficult. The truth does not belong to one side. It belongs to the people. And it is only preserved when citizens demand that their leaders, their prosecutors, and their judges are held to the same standard, no exceptions, no hidden orders, no silent signatures. If you believe that accountability is not optional, if you believe the rule of law should never bow to politics, then stay with us. Subscribe to Liberty Report USA. Support our work to expose the truth and to keep shining a light where others would rather keep the doors closed.